Good morning and welcome to the 36th meeting of 2025 of the Economy and Fair Work Committee. This morning we are taking our final Stage 1 evidence session on the Digital Assets Scotland Bill. But before we commence, I would just note that we have apologies from our colleague Murdo Fraser. So for our final evidence session, I would like to welcome Richard Lochhead, the Minister for Business and Employment, Kieran Burke, Team Leader for the Digital Assets Bill, Liam Hepburn, Senior Policy Official, Fraser Goff, Parliamentary Counsel, and Emma Phillips from Legal Director, all from the Scottish Government. And I'd like to begin by inviting the Minister to make a short opening statement. Richard Lochhead.
Thank you very much, Convener, and good morning to the committee. I appreciate the opportunity to speak with you all today about the Digital Assets Scotland Bill, which implements key recommendations made in 2023 by the Digital Assets and Scots Private Law Expert Reference Group, chaired by the Right Honourable Lord Hodge. The purpose of the bill is to clarify Scots law by confirming that digital assets are capable of being objects of property. Digital assets have become an increasingly important component of financial services and economies across the globe. The proliferation of digital assets is continuing at pace. These assets, which are often recorded on and transferred through distributed ledger technologies such as blockchain, provide significant economic opportunities. It's estimated that the value of blockchain technology and the market to Scotland is likely to reach £4.48 billion by 2030. Wider adoption of this technology is expected to bring about improvements in supply chain activities, healthcare systems and financial transactions. The Scottish Government places importance on supporting a business-friendly environment and economic growth, including across the specialist digital asset trading businesses and asset management and the financial technology sector known as fintech. Individuals, not just businesses, are using digital assets for payment and investment purposes. Bitcoin, the most well-known cryptocurrency, was trading at just under £300 about 10 years ago. At the start of this week, that same asset now trades at just under £65,000. In addition, the Financial Conduct Authority's consumer research in 2024 showed that 12% of UK adults hold crypto assets. In other words, around 7 million people. So on that basis, the estimated figure for Scotland is approximately 540,000 adults. So with this figure expected to grow, it's appropriate that our legal system provides greater legal certainty for our citizens when it comes to the assets they choose to increasingly use for payments and savings. As the committee is aware, digital assets are not readily incorporated by existing classifications of property under Scots law, which creates legal uncertainty. The bill seeks to address this by providing the necessary legislative foundation for Scots law to accommodate modern business practices, and I, like most of the witnesses you have heard from, I think it's fair to say, think we have achieved that. So the bill is a short piece of legislation with a narrow scope of application, and that is deliberate. The bill is restricted to providing certain digital assets with property status. It achieves this by confirming what is meant by digital assets for the purposes of the bill, by categorising these digital assets as in corporeal, movable property, and finally by establishing basic rules on the acquisition and transfer and ownership of these digital assets. Scotland is not unique in needing to reform its laws to better accommodate digital assets. Many jurisdictions are legislating so that their legal systems and property laws appropriately incorporate these new technologies. However, this bill approaches the changes required from the unique perspective of Scots law, and I'm glad to bring forward a bill that will bring our legal system into line with other developments across the UK and internationally in recognising certain digital assets as objects of property. So I have also read with interest the evidence provided to this committee. I'm pleased to see there's been broad consensus on the general purposes of the bill, and I look forward to working with the committee as the bill progresses. And of course, my officials myself are ready to do our best to take your questions today, especially my officials, given there's a lot of legality amongst this topic that we're going to be discussing.
Thank you very much, Minister. I wonder if I might open up questions by asking for what you and your team's reflections have been on the evidence. You referenced it there, and I think if I was to summarise it, there is broad agreement that there is a need to ensure that we incorporate digital assets into Scots law. That the framing of the bill, I think, has received broad support, but there have been questions, I think, in broad terms, maybe around the clarity and also in terms of what may or may not be captured at the margins of the definitions. And I would reflect that that's not necessarily a sort of a universal, but those are maybe some of the points that were raised. I mean, what are your broad reflections on the evidence that the committee's heard, and have there been any reflections and thoughts from the government as a result of that?
I was listening to a lot of the witnesses you were hearing from, and there was a lot of really important points made and pertinent points about not only what's in the bill and the purposes of the bill, but obviously some of the wider issues arise from the bill. I think there were legal voices, and there were other voices, perhaps from a more technology perspective. But I think it's important to note that those from the expert reference group that gave evidence, as well as the Law Society, the Faculty of Advocates, who focus more on the legal aspects of this bill, because it's a limited scope, this bill, just focusing on giving legal certainty to digital assets as property. I think they virtually unanimously felt this was an important bill, there was a need for it, and it achieves what it's setting out to achieve. So some of the other issues that were raised, I think, were addressed by the witnesses who support the bill. But they're part maybe a wider debate, and this bill can't deal with everything. It's just dealing with a narrow focus. There was lots of other issues around blockchain technology and all kinds of things, and the margins and the debates that may arise in the margins of the bill. But as I said before, I think that was from a part of a technology debate, and this bill is not appropriate to address some of these issues.
Yeah. I wonder if I might sort of just probe some of those points, especially around sort of the fundamental definitions. I mean, first of all, I mean, I would note this bill is framed in terms of things that arise from electronic systems that are rivalrous and immutable. And certainly in terms of those last two concepts, those are concepts which the legal witnesses said were clear, but they're not kind of long-standing features of Scots law. And when I look at other jurisdictions and how they have sought to capture similar concepts, they've gone about it in a slightly different way. Now, and this is notwithstanding the other elements which are the wider scope, just in terms of narrow definition. So if you look at the Australian bill, for example, it talks about an electronic record that one or more persons are capable of factually controlling, and that it then goes on to sort of describe that factually controlling means that those people may either solely or jointly be capable of then transferring it. I.e., I think that's capturing a similar concept to rivalrousness, but perhaps in plainer language. I mean, is there a potential issue in terms of using concepts like rivalrous and immutability, which are maybe less clear in terms of everyday speak, even if legal experts would claim that they are clear, especially if they're novel in Scots law?
Clearly, Scots law is distinctive, and I think if you were to look at many Scots Acts of Parliament, you would not recognise law phrases. So I'm not sure there's anything unusual in having some obscure phrases, perhaps, as far as the general public are concerned, in our legislation. Clearly, this is something the expert reference group felt was appropriate, and rivalrous is a commonly used concept in economics and business, and they felt this was appropriate. In terms of coming up with legislation where we're dealing with now the modern world of digital assets being immutable in that it can't be changed, the records, is very important for being rivalrous. in that only one person can use it, so a second person can't use it because one person is using something, and therefore they're very interlinked. So that's the approach that the expert reference group took, was that we have to define property in a digital world, and this was an appropriate way to do it. So I think there's lots of jurisdictions have been taking forward similar legislation. I don't pretend to know what's in other countries' legislation because there's been quite a lot of countries doing this. But obviously we just have to take our guidance from the expert reference group, who obviously I think explained their rationale to yourselves, and they gave evidence that this was the best way forward.
I mean, could I just ask, just again, was there a particular reason why it was more appropriate to use the terms that are used in the bill as opposed to sort of language similar to that of the Australian bill when the bill was being drafted? I mean, was there a specific reason why Scots law needed, those discrete terms rather than a broader description of what kind of rivalrous or exclusive control might look like?
I think some of the tight definitions using those words that you're referring to, my understanding from the expert reference group and also from the evidence that was given this committee was to differentiate in terms of electronic documents not being all defined as property. We have to define what's property and what are other types of electronic documents. And obviously the examples that were given to the committee and have been by the expert reference group is, a digital image or an electronic document, emails or whatever, is not defined as property in Scots law. So therefore they have to differentiate between different types of electronic documents. And therefore that's why these other definitions of immutable, rivalrous comes into play, is to differentiate between what can be easily copied and what can't be easily copied and what's property.
So my question wasn't really about whether or not you need that. I think that's it's relatively clear for exactly the reasons you set out. It's just whether or not that using the term sort of rivalrous in particular, rather than using language like exclusive control, and whether there was a particular reason why using what is a sort of a novel term, and certainly one that's not in common usage, was used as opposed to a sort of maybe slightly longer form but plainer language definition for that point that you can have. It belongs to one person and they can control what happens to it.
I'll bring in Fraser because he
Yeah,
wants
that
to
would be
to
really,
explain the legal background.
Yes, I think, taking your point on the Australian bill to begin with, I think as Greg McCone said last week, that's a very different bill for a different purpose. And as Professor Fox said in the first session, referencing certain electronic financial regulations, again, there's a danger in looking at other legislation crafted for different purposes and just picking as a hodgepodge, well, why couldn't you have used this word that other act that was created for a totally different purpose has used? It's rather hard to kind of go through all the other words that people might have used around things and say, well, why is that word not better? The brief for this bill was to give effect to the expert reference group's recommendations, and I can't speak to whether or not any other jurisdiction's legislation would or wouldn't have given effect to those recommendations as effectively. The choice of rivalrousness and its obscurity, with legislation, one always has to think about the audience and for whom is a term obscure. And if you're writing for a particular expert audience, perhaps using language that's not the language they use actually is more obscure to them because you're defining in ordinary language things that they have words for, single words for, that could very readily get them over the difficulty. In the course of drafting this bill, once you start to read the literature about the law and the problem the law has to solve, the word rivalrousness very quickly becomes not so obscure to you, becomes a word you find in every other paragraph. It's very much the terminology that's used, and by using that word in the bill, it makes it easier in some ways for the court to pick up on the intellectual inheritance behind this bill. So when they go to look for extraneous sources and to aid their interpretation of what the overall policy intent was, having a bill that speaks very directly to the wider legal debate has its utility. which isn't to take away from the issue about the accessibility of the law, which of course we take extremely seriously. On that point, I would make the observation that rivalrousness is used in this bill effectively as a label in the first subsection. The very next subsection tells you in far starker terms precisely what it means for something to be rivalrous. So nobody is expecting anyone to come to this with their own definition or conception of rivalrousness. We're just using it as a label because it's the shorthand with which people who've been looking at this are most familiar. But for those who are not familiar with it, the very next subsection is going to explain what it means, in much the same way that the statutes which use exclusive control do, where they use exclusive control as a label. But of course, exclusive control doesn't at all mean what you might think it means, because it's going to be defined at some length further in the enactment.
Thank you. Similarly, immutability is the other concept, and we heard from Professor Fox that this may not require absolute immutability, and in the most fundamental sense, we're talking about virtual things that exist as electrons in kind of hard disk memory banks and in a distributed way. So therefore, they're not in an absolute sense immutable at all. But is it problematic that we're talking about, kind of hard immutability, either physically or indeed conceptually? Professor Fox was saying that it may not be absolute immutability that is sort of a practical, or as if these things are operating as they should, they are unchangeable. Is there a problem that there's actually sort of a fuzzy margin to the concept of immutability with regard to this bill?
I noted the points made by the witnesses, but I think the witnesses also said that they felt it was satisfactory, and clearly this is linked to avoiding double selling, and there has to be safeguards in place to avoid double selling, and therefore the systems used have to be immutable and that they can't be changed, and records cannot be changed. So ultimately it will be for the courts should they have to look at this in detail, but I think anyone reading this will know what's being asked of the legislation, what it means in terms of, not tampering with records. We can't allow a system to allow double selling.
Thank you. With that, I'd like to bring in my colleague, Sarah Boyack. Sarah.
Thanks very much, Convener. Several witnesses from the technology sector have given evidence to the committee, and their view was that the concept and the definition were not easily recognised by those working in the field, and there were several suggestions given to the committee on this, including guidance, statutory guidance, or further clarification in the explanatory notes. So how does the Scottish Government intend to bridge this gap?
Yeah. Clearly we'll reflect on that, and particularly the point of explanatory notes, etc. I think other witnesses also said that they'd be reluctant for guidance to be issued because of having certainty with what's in the bill, and they're content with that. And presumably they were saying that they want this to be technology neutral, and that the world may change in the future, and we can't predict what that will be. So the more we're prescriptive, the more that could cause issues in the future. But I'm happy to reflect clearly on that evidence. Again, I noticed there was a slight differentiation between the evidence given from those who were coming from a very legal perspective and those who were coming from a wider technology interest. So those representing wanting the law to be clear as to the property status of digital assets were content. Obviously, there was a wider debate over some of these other issues that others mentioned.
I suppose the challenge is we need to get all of it right at the same time, and to think about how you future-proof. So, in evidence to the committee, Professor Robbie highlighted the power of property rights and the risk of unintended consequences if certain items were given property status without thinking through what that impact would be. And you've just talked about thinking ahead for the future, but there isn't actually anything in the bill about how you future-proof this legislation. So, where's that going to happen? It's not in the policy memorandum. Will the Scottish Government commit to undertaking an audit of the potential impact of the bill across government and non-government activities?
I'm clearly happy to give consideration to that, and obviously the committee will publish its report, and if there's recommendations in there, we'll treat that very seriously. There was a whole debate over carve-outs and trying to give more certainty through perhaps carve-outs being mentioned of what's excluded in the bill. Again, other witnesses said that we shouldn't go down that road, and they were content that what was in the bill was defensible and achieved the right balance. So I can't give a categorical answer to that, but obviously we'll reflect on what the committee say in terms of further
I suppose it's
clarification.
the fact that we have to think both from those two different perspectives, but also think about how the bill operates and how tech changes over time. But this morning, just reading through evidence, supplementary evidence from Greg McClurdy, following his evidence last week, he was referencing Professor Robbie's evidence and talking about a potential financial risk to the Scottish Government in relation to carbon credits and their relation to the Woodland and Peatland Code. So you've both got high-level issues, but also witnesses giving detailed evidence about concerns that they've got. So I was hoping that the Minister would pick that up. We can't get everything perfect, but when people are actually raising concerns at this point, the issue of guidance or the policy memorandum, we need to have these issues actually teased out. Would you agree?
I'll reflect on that. Whether carbon credits or anything else is identified as property will just be how the bill is interpreted. The bill's there to lay down the key principles of what would define digital assets as property. So whether it's carbon credits or anything else, it'll just be dependent on what's the definition of property in a digital world. So, and when you're, in terms of future proofing, I think again witnesses made this point. I was reading, I think maybe it was Lord Hodge, maybe it was Professor Fox, that all we can do with this, to a certain extent, all we can deal with is the here and now, because technology is changing quickly. So we can't really future-proof something, and the world's changing so fast in terms of where we'll be in 10 or 20 years. And I think there's an acceptance that Parliament might have to deal with that once it becomes clearer. But in terms of this bill, it's really about dealing with the here and now. So, and I know that's a kind of open-ended debate, and people might have their own views on that, but I think that was quite good points made by the witnesses.
So it goes back to that the last question I asked about whether the government would consider an audit of the potential impact of the bill across government and non-government activities, just to reflect on that.
Yeah, I will reflect on that, and again, if the committee recommends that, we'll take that on board.
Thank you. Back to you, Convener.
Just briefly as a supplementary to that, so I mean, Professor Robbie, I think, made the specific point as to whether or not carbon credits should be specifically carved out. And I think her point was that once you've basically created something as property, it then actually makes it very difficult for the government then to exercise control because of the nature of property rights. And I just wondered, I'm certainly not expecting an answer this morning, but is that actually a very specific point around carbon credits something that the government is reflecting on, given it was a specific point made by Professor Robbie?
I noted that evidence, so we will reflect on that. Is all I can say at this point.
Thank you very much. With that, I'd like to bring in the Deputy Convener, Michelle Thompson. Michelle.
Good morning. Thank you. Thank you for joining us. And I suppose kind of following on from that, potential exclusions at the moment aren't just voluntary carbon credits. It's also electronic trade documents and securities traded on CREST have been excluded because there's already legislation in place that deal with them. How confident are you that you've captured everything in terms of exclusions? And it's a kind of counter to what you're saying, Minister, about, well, we need to start somewhere, but are you sure you've managed to exclude everything in terms of other types of vehicles that we want to make sure that there's not greyness that creeps in as a result of this bill?
Well, we are confident, and clearly the aims of the expert reference group were to establish key principles and reflect them in this short bill that therefore defined what would be counted or classified as property in terms of digital rights. So that's there. and therefore we to start working up lists of what's excluded. That's a different approach altogether. You know, that it's like a sort of devolution argument, isn't it? Of what's reserved, what's devolving. You just leave everything devolving. Right. So that's the approach taken by the expert reference group, and that's what we're content with, is lay down the key principles in law of what defines digital assets as property, and clearly if something does not achieve those thresholds, then it will fail the test.
Okay, and in terms of going forward, I mean, I fully accept what you're saying about, well, we need to start somewhere and we can't start with perfection. I think we all understand that. But in terms of approach, because the potential interface and complexity, legal complexity, with a whole number of different laws is going to start to be fleshed out and deepened as we go forward. Are you happy that at the moment you've got the threshold right, if you like, that will allow that to happen? Because I fully accept that there'll be things that none of us know, we can't be expected to know, and that's okay, but we're having to hazard a best guess, an educated guess about, well, what we know at the moment to make sure that we get the balance right. Are you confident about that as well?
I think the approach we're taking is the correct one. At the moment, there's commercial activity taking place, and therefore the purpose of this bill is to recognise that commercial activity is already taking place out there. Therefore, we have to give legal certainty to it, and that's the reason why the Lord Advocates, or third last Lord Advocate, or whoever it was, commissioned the expert reference group in the first place, is because this was already happening in society. But we need to give legal certainty to the trading of digital assets and recognise its property in the way that we recognise other assets as property. So that's what this deals with. And I think, again, some of the witnesses you heard from, including members of the reference group, were saying that, yes, things will change in the future and Parliament will have to return to this. But at the moment, there's this requirement to deal with this specific issue, and this does the job.
Okay. I wanted to ask a question about tokenisation, which you may have seen came up quite a lot in our discussions, because the bill is silent at the moment, but we know it's a growing area. And I think the area that we kind of stopped on is it's not always clear that transferring ownership of a digital token is transferring the underlying asset. What's your thinking about how that might be approached? Because that is fundamental, both under law in terms of the approach and also tokenisation, and Scotland's place in utilising tokenisation is important, and we're already there, and therefore that could bring greater value to the economy and so on. I appreciate that's quite a technical question, so if you want to bring in anybody else, I'll be quite happy.
I am going to bring in colleagues. I know Kieran was keen to come in on your previous point as well, so if I can bring Kieran from a policy perspective, and we'll come back to your tokenisation point.
Yes, thank you. It was just really in relation to the issue in relation to carve-outs, which you'd mentioned as well, and obviously we've heard from some witnesses that there would be a preference that certain things get carved out. The approach that's taken in the bill is to have a very broad brush kind of definition, an open definition, and that's to help with the future-proofing aspects of the legislation, because the pace of change is quite quick and rapid. In relation to the evidence that you have heard about certain things maybe should be carved out, such as electronic trade documents, there has been a very broad assumption made that they might be appropriate to be carved out, but we haven't really heard the detail as to why or what the particular issues are in relation to the conflict of what this bill is seeking to do. So I suppose I would just add as a note of caution that if we could hear what the specific issues and any potential conflict would be in relation to that, then we could consider it further. But at the moment, it just seems that there's an assumption that there may be a problem without articulating what the actual problem to be addressed would be, and therefore how we could address that in the bill itself.
And just before we move on to the next point then, I'm sure as you were watching the previous sessions, our previous witnesses will also be watching this. So I think you issuing that clear call, if you're looking for more information, I'll reiterate, although they need to do it quite quickly because we're up against it in terms of timescales, as I understand it. So then the question about tokenisation and this kind of fundamental, what's our thoughts about that?
Fraser, come in on the legality around that.
Yeah, I mean, I think what I'd say listening to some of the evidence on tokenisation is What this bill is trying to do is a very specific fix to Scots law, which is that there are these things out there now which, to all intents and purposes, work very much like corporeal property as we've always understood it. But they are not corporeal. They lack a corpus. They're intangible. And this bill's fixing that by saying it doesn't really matter that they lack a body, as long as they meet this other condition that makes them rivalrousness, which is one of the things that having a body provides you, right? You can't double spend a coin because it's a physical thing. Here, the blockchain effectively operates the same way and prevents you double spending. So what we're saying is because this technology has solved that issue for these intangible things, we're happy for the law to treat them as property like corporeal things. When the law came to recognise corporeal things as objects of property, we didn't begin with, well, what could you tokenise these things to be? And then deal with the law almost backwards by saying, well, I'm refusing to recognise a piece of paper as an object of property because you might tokenise that piece of paper to represent a debt obligation, or you might tokenise that piece of paper to represent a carbon credit. That would be a very strange way of going about it. If you're interested in regulating carbon credits or anything else that you might care to tokenise, you deal with the tokenisation of the thing as a separate legal topic. You don't deal with the thing that you're capable of using as a token. Could be a digital asset, could be a marble. Doesn't really matter. So in terms of the bill's silence on tokenisation, I'm not really sure what this bill could meaningfully and usefully say about tokenisation, because whether or not you think it's appropriate to say transfer property instead of on the land register, to have that done via the blockchain and use these digital tokens rather than an entry in a physical register. Certainly you could have that debate, but that's surely a debate to be had in the context of a Land Registration Act, going into the details and the nuance of land registration, rather than trying to deal with the tokenisation of anything and everything that could conceivably be tokenised to a digital asset through a digital asset statute. It's too abstract.
What you're saying makes sense, and you're applying understood principles, and it touches on this merging between what the kind of digital guys understand how things are actually operating and core principles arising from historic property law. And I understand that. But the very first example I asked in the first session was where you have generative AI and you may have an amorphous entity, a thing, that is constantly evolving. It's, you know, the AI is so advanced that it's constantly rewriting itself. Trying to then fix on what is that thing may inevitably be defined by its token. And that's why, and I'm always slightly embarrassed to say this because I'm sure some of the tech guys will go, no, Michelle, you've not got this quite right, but nobody's said that to me thus far in any of these sessions. So I don't necessarily disagree with you, but I'm not convinced, and that maybe I'm not eligible enough to be convinced that there will not be situations like that, and that very quickly the only pivot we're going to have is a digital token. Does that make sense? And therefore, have we really got, like, bottomed out the consideration of why tokenisation is so important?
I think, you know, from my limited knowledge of other jurisdictions, what they're doing, these are dilemmas I think all countries are facing in all jurisdictions. We don't have a solution to that growing, potentially futuristic problem in this bill, because this sets down thresholds or tests for what would be deemed a digital asset and as property. So, you know, it's up to the courts then to decide if someone's to challenge it, perhaps along the lines of what you're speaking about in terms of AI and what may be deemed as property produced by AI. That would be really up to the courts to see if it passed the test in this bit of legislation. But yeah, I mean, these are big issues for the future.
Do you want to add anything, Fraser?
No, I mean, I think as Lord Hodge and Professor Fox said in the first evidence session, AI is undoubtedly going to present a challenge to the legal system in all kinds of respects. And no doubt there will need to be an AI statute or many statutes dealing with it in particular contexts. But this is merely another one of those, I think.
Okay. Thank
Thank you. I'd like to bring in Willie Coffey.
Thanks very much, Convener. Good morning, Minister and colleagues. I just wanted to ask your reflections on where Scotland sits with this legislation compared to other jurisdictions. We've had a little bit of discussion about what other countries are doing. So where do you see us positioning ourselves with this particular bill? Are we playing catch-up? Are we ahead of the game? Some of those giving evidence to us in recent weeks described this bill as very elegant, particularly elegant. So it was just to get a flavour from you and your colleagues about where you see this bill sitting in terms of other jurisdictions.
I think we're one of many jurisdictions that are trying to modernise their law in terms of the property law to take this into account. Other jurisdictions have literally just passed laws in the last few months. I think the UK's is pretty fresh. So we're not behind, but we need to modernise our law, and that's the purposes of this, is because the economy is changing so fast. So I'm confident that we are moving at a reasonable pace.
I mean, when you consider the kind of international, the global dimension to all of this, and so many countries perhaps having peculiar and specific legal frameworks to manage it, how do you foresee the problems of dispute arising and being resolved if jurisdictions have different approaches to this for essentially global digital commodities that are out there and that we understand? Perhaps one for Fraser to offer a view on as well.
So you're looking at Fraser, so I don't know if Fraser stands for that.
I think the international private law challenges here are undoubtedly acute. The Law Commission in England and Wales is currently looking at that, I think Lord Hodge mentioned, and plans to report, I believe, next year on how all of that will be managed. So, again, in some ways, new things, old problems. The international flow of things and the rules of international private law and what law governs has long been an issue. I think a lot of this takes us into reserved territory, of course, because we're dealing with things Firth of Scotland. So I think certainly in the first instance, it will be a case of see what the Law Commission in England and Wales recommends at UK level, and then where Scotland wants to position itself relative to that.
Do you see Scots law having to develop beyond this bill to deal with issues like that? For example, dealing with debt, for example, and disputes about debt and who owns who, what, and who's used my property illegally. This bill will help to define that framework, but taking it further into the spheres of international debt and personal debt and dispute, is that going to be another bill beyond this, do you think, that we will require in the next Parliament?
Well, I was going to say not my problem, but in terms of
Colleagues would love that response, Minister.
yeah, I mean, clearly this is, a fast evolving situation, and the law is going to have to be agile moving forward, because we can see where the world's going and with technology and digital transactions in the future. So I can't sit here and predict what the big issues will be in the next few years. But yeah, there's going to be more and more need to understand implications for Scots law. I think, as Fraser was saying, from all these developments are happening in the future, and governments around the world are wrestling with this. This is a global phenomenon.
Maybe finally, I mean, in your opening remarks, you defined it as the bill being narrow in scope, deliberately so. Is that a particular strength, do you think, of this bill? Because you've heard all the discussion about what more should go in it and what should perhaps come out of it. Are you quite content that the approach, the scope of the bill is the correct approach?
I just bring the committee back to the fact there is a lot of support for this bill, and its short, sharp focus. And whilst there's other debates at the edges and around technology changing, what that will mean in the future, and many witnesses spoke about that, there's a lot of support for this bill and the need for it now.
Okay.
Do you want to?
Kieran?
Yes, thank you. In terms of, obviously, we had a consultation to help develop the policy in relation to the bill, and some of the questions were asked in that in relation to, do we need a piece of legislation at all? And secondly, should we have a narrow focus piece of legislation to deliver certainty around, or greater legal certainty around digital assets? And there was 88% support in terms of favour for the legislation itself, and 66% support in favour of keeping a narrow focus in relation to what the legislation should contain. So the policy has developed and the bill's been produced on that basis.
Thank you. Thank you very much for that. Thank you, Convener.
Thank you. I'd now like to bring in Stephen Kerr. Stephen.
Minister, I don't know. I don't think we're fellow graduates, I think, of the University of Stirling, but neither of us did law. No, and I certainly didn't. My background, like yours, is certainly not in law. It makes me somewhat uneasy to hear the kind of things that Fraser has, in all honesty, presented to us this morning, that this law is being written, as it were, in the language of legal experts, but in terms that lay people, let me call us that, are not going to readily understand or recognise. And that does lead, obviously, to concerns about how people will operate within such a law that they don't really understand. And one area of concern clearly is in relation to acquisition. Someone who, I mean, the bill protects acquirers in good faith, but it doesn't actually say what that good faith means. I do apologise to the Minister because I'm almost looking past him towards Fraser when I asked this question, with great respect to the Minister, because it doesn't say what good faith means. It doesn't talk at all about due diligence. Why in drafting the bill did you go down this route? I will ask that to the Minister, but I'm sure he'll probably want to refer it to others.
Yeah. Well, this bill arises from Scots law, which has been around for centuries, clearly, in terms of our distinctive legal system. And the bill will be recognised by the legal profession, who it's primarily aimed at, in the courts. This is for the courts as well. And the issue you raise, of course, I think applies to a lot of Acts of Parliament and laws in terms of ensuring it's accessible and uses language the public understand, and I can sympathise with that. But it's got to be legally sound at the same time, and we will ensure that the explanatory notes, which are more likely to be used by the public as opposed to the actual Act of Parliament, are very clear in explaining what everything means. I'll ask Fraser to come in the point of acquisition.
Specifically about good faith, what that actually means. And the issue of due diligence, particularly in the areas of these incorporeal assets.
Yeah, so there's a kind of there's a drafting question there, and also a slight policy question as well. On the drafting point, what does good faith mean? Is that a term that would be readily understood by the average citizen? I don't know if it's a particularly abstruse idea, is it? If you're in good faith about something, I mean, I don't know that it's a more obscure phrase than due diligence. Undoubtedly, though, you know, the target audience, ultimately, if there were a legal dispute about the ownership of something, is going to end up in the courts. And so, as the Minister says, making sure that this is written in a register, that the courts will be able to apply the law in the way intended, is very important. And the way intended here is that this innocent acquirer rule will operate in the same way that other innocent acquirer rules in the law operate. For example, in the Civic Government Scotland Act, 1982, Bills of Exchange Act from the 19th century, good faith is simply the word that is used. This is the expression that's used to deal with this good faith acquirer rule. The bill replicates the words because we mean to replicate the effect. If we used different words, the court would have to ask itself, well, why have you not expressed this the same way all these other good faith acquirer protection rules have been articulated?
But would that not be because this is an intangible? I mean, if you're buying an object, you have the object in front of you. a house, whatever. This is intangible. Doesn't it require an additional layer of protection for buyers?
Well, so this then brings us to the further policy question, which is not merely why the expression good faith, but should there not be some additional requirement, like a due diligence requirement,
due diligence,
which
yes.
is what good faith in some ways sidesteps. I mean, Lord Hodge answered this in the first evidence session, I think, making the point that the purpose of these innocent acquirer rules was to promote confidence in, well, as it was then when these rules first started to emerge, these new paper bills of exchange, and people needed to be able to trust that if you've been given one, it's yours and you don't have to look terribly far behind it. And it would undermine the policy, therefore, if there was a requirement for a lot of due diligence to be done. And as Lord Hodge said, the recommendation of the expert reference group was to take essentially the same approach for essentially the same reason. We want to promote market confidence in these things. The difficulty with a due diligence requirement isn't really fundamentally different because they're intangible. The house in front of you no more bears a sign on it that says, I've been illicitly acquired, than the digital asset does. The provenance of how it is that the owner, the person who purports to be transferring it to you, comes to have it, is always, in a sense, an intangible thing. So the intangibility of the asset itself doesn't raise any particular new or acute problem. The challenge, if you went down the road of requiring a due diligence requirement here explicitly, is simply that these things on the blockchain are being traded very, very quickly, often. So, I mean, more than even with the paper bills of exchange. When you're 10 layers of transfer down, and somewhere at point 9 on that block, somebody didn't have proper title, you're now unstitching quite a long chain of transfer. Now, you might think the equities of the situation demand that the original person who lost the asset should get it back, nevertheless. But that goes to the policy rather than the mode of expression.
But you do introduce this idea of protections around the original owner in case of theft or indeed fraud. How, in the bill, how is it expected that the original owners obtain effective redress?
Well, that would be a case for the wider legal system. All the bill is dealing with is identifying what is property. So if you sell something to Willie Coffee and it really belongs to Lorna Slater, Willie Coffee would own the property, but you'd sold it, when you shouldn't have. Therefore, you would be sued for damages, in theory, by Lorna Slater. And it would be the wider legal system. It's not for the bill to determine that. The bill is determining just what is property.
Right. So there's no intention in drafting that there should be any.
It's not the purpose of the bill to solve disputes. It's just to determine what's digital property. There's other legislation, to do with all these issues, but this particular bill is just about identifying or classifying digital assets as property.
Okay, so there's no intention in the bill to provide levels of protection to the original owner.
It's just determining what's classified as digital property.
Yeah.
Other legislation deals with all these issues of
at its
people
simplest,
who've been conned out of money or, the law's been broken. But this, you wanted to make there, sir?
If it's helpful, in relation to some of the evidence that you have heard from other witnesses, I think it was touched upon that they were of the mind that the ordinary civil remedies which are available would apply in relation to this bill. There was some discussion as to whether the court rules themselves need to be looked at in terms of the court rules, if they needed to be looked at to see if they could be updated. But it wasn't specific just in relation to digital assets. It was in terms of how diligence acts more broadly in relation to persons unknown, I think was the example that was given. So yes, this bill is not seeking to address any particular new remedies or bring new remedies into play because we think that the existing legal system accommodates that.
All right.
Sorry, if I may, Minister. I think Emma Phillips was wanting to come in. Would you like to bring her in?
Yes, I'll bring in Emma Phillips.
Thank you. Can you hear me in the room?
Yes.
Excellent. Just wanted to reiterate the point made by my colleague Kieran Burke that by defining digital assets as objects of property, as the digital assets are defined in the bill, this will result in the existing Scots law rules in terms of remedies available to apply to digital assets as appropriate. So it's the bill itself doesn't need to make specific provision because the effect of the bill is to apply those rules as they exist already to the digital assets, and so that it's not necessary to make further provision. As my colleague Kieran said, the committee has heard evidence to reflect that the remedies existing are already sufficient in this respect.
That's quite clear. I don't know why I said that in relation to this bill, but something's quite clear. But in this instance, I think it is.
Thank you very much. Is that,
yeah.
Fantastic. I'd like to bring in Lorna Slater. Lorna.
Thank you, Convener. My first question is sort of been touched on, but I'll just get the Minister to extrapolate a bit further, and that is about what regulations may be needed or what legislation may be needed to apply in future to digital assets in order to either protect institutions such as the banking systems, support Scottish or EU interests, for example, hinder bad faith actors, protect investments, and so on. So this bill, as I understand it, simply makes digital assets exist in Scottish law. It doesn't provide any further regulations for the protection of anybody. What intentions does the Scottish Government have to consider such regulations in the future?
My understanding, and colleagues will correct me if I'm wrong, is that at UK level there's some work going on looking at other issues arising out of digital assets and the digital world. So I don't think we're in a position to answer that question yet until we see what these reviews are looking at and what they come up with. And then, of course, just as we had a chain of events that led to this bill being necessary in Scotland, there may well be a requirement for further bills in the future. So there's a number of issues being looked at by the legal profession, particularly in England and Wales, which obviously I think this was mentioned by some of the witnesses as well, that we'll take into account in Scotland. So yes, I think it's likely, obviously, that there'll be a requirement for more legislation in the future as this develops globally and a lot of the implications become clear and the impact on Scotland and Scots law. But at the moment, clearly, it's difficult to say exactly what.
It's a fast-changing dynamic playing field, as it were. And would it therefore make sense to put within this bill regulation-making powers such that the Scottish Government is able to react more flexibly and use secondary legislation to kind of keep up with things rather than having to go to primary legislation to make such regulations in the future?
So there is ability to bring forward regulations in the bill at the moment. So that option is open to us in the future. We just can't, obviously at this point, say in advance what the need for that will be, but the ability is there in the bill. I think Fraser wants to just kind of...
Yeah, so the bill contains an ancillary power which allows us to make modest adjustments in other areas in consequence of what this bill does, which is fundamentally, as the Minister says, recognise digital assets are objects of property. The levels of more thoroughgoing regulation of particular areas of the economy as a consequence of the recognition of digital assets may be beyond the scope of that power. They may also be beyond the scope of this Parliament. I think I've tried to say in a previous answer, there's maybe a danger in thinking too much here about the regulation of digital assets, qua digital asset, as opposed to the sectors with which you are concerned. So if one is concerned about regulating the financial services sector, it may be that what you're really interested in regulating is particular financial instruments. The fact that they've been tokenized and made into digital assets is almost by the by. Now, that would be an example of something that's very likely to be out with the competence of this Parliament and couldn't be regulated here. Similarly, touched on previous sessions, the question of carbon credits. Again, one might well want to regulate the carbon credit issuance sector. But is that fundamentally a question of the fact that the things that are being used to tokenise the carbon credits are digital assets as opposed to marbles? Not really. So I think there might be kind of two tracks of regulation that is needed because there is a specific sector which needs regulation in its own terms, whether they're using digital assets or not, and then things which are peculiar to digital assets which may require law changes, which, as discussed with Mr. Coffey, for example, international private law questions might fall into that category because they are specific to the unique question of non-corporeal things now being recognised by the law. So that's a particular issue to do with this, not a wider issue of regulation.
Thank you for that explanation. So I understand then that the regulation-making powers within this bill are relatively narrow to kind of keep it within the scope of the bill because, as you suggest, allowing powers to modify regulations that may affect the whole banking sector, for example, wouldn't be within competence either of this Parliament or necessarily of the bill. Okay, that's helpful. Thank you. My second line of questioning is around environmental concerns. So the generation of some of these digital assets does require an enormous amount of energy in terms of just the sort of number crunching that's required to generate bitcoins, for example. I realize that this bill is not by itself making digital assets exist. They already exist. All we're doing is recognizing it. But by recognizing it, we have heard from other stakeholders and witnesses here that it will prompt investment. They want this sector to grow. That implies an environmental overhead, an environmental impact through that energy generation. Is that something that the Scottish Government has considered with this bill? And where do those environmental concerns sit in relation to digital assets?
Not directly in relation to this bill, but clearly in terms of the wider policy developments around data centres in Scotland and equipping Scotland for the future and the AI revolution. And as you say, the more the world's going digital, the more demand there'll be for energy. And clearly our policy is to have green energy data centres in Scotland. We've already seen that CoreWeave have chosen Scotland to establish a data centre. That's their proposal at the moment, and clearly we'll see how that develops over time. And they chose Scotland because of a renewable energy potential, and they've said that publicly. Yes, you're right, this is part of a wider digital revolution that's taking place, and that's got a big energy footprint that we have to make sure we deal with that properly for environmental reasons, as you say. So it's a global issue at the moment as well, as you'll be aware. There's quite a significant percentage of the world's energy is now being used for data centres. So green data centres is our policy to try and utilise our renewable energy potential for data centres, because clearly, that's an advantage we have.
Where does the environmental assessment for that sit? So I guess the problem is if we're doing this in bits and pieces, as Mr. Gough suggests, where this bill creates the digital assets. There'll be another bill that regulates them in the banking sector. There'll be something else that regulates them elsewhere. We're seeing the growth of the data centers and the computing power needed to manage all this and generate some of the assets. Where's the environmental assessment happening? Because it's kind of growing behind the scenes, isn't it? So where do we do that assessment and see how that fits into the Scottish economy?
Well, all developments are subject to environmental assessments, as you're aware, and that will apply to data centres being built as much as any other infrastructure for AI or for the digital revolution taking place. So I'm sure as this policy evolves, we'll have to have more answers to those sort of questions, because if the demand for energy is going to just get bigger and bigger and bigger as the years goes on, we're going to have to calculate what that is and what the impact is on Scotland of that demand for energy. And as you say, look at environmental assessments for that to make sure we're working within our limits.
Yeah, just to add to your point around the sort of environmental considerations, I know that we spoke in length across this session and other sessions about cryptocurrencies. Bitcoin usually gets a lot of the popularity. So for context, Bitcoin takes up about 50% of the total money that is in the cryptocurrency market. It's a very energy intensive resource. It takes a lot of computational power, and we do recognise that. But for example, as well, the second largest cryptocurrency, Ether or Ethereum, on the Ethereum network, for example, which takes up about 12% of the cryptocurrency market, uses around 99% less energy than what Bitcoin does. So we obviously would always encourage businesses to use, the most environmentally or the most optimal way that would, in line with the environment. And I guess it also does in some cases make business sense, if they're looking at sort of ESG sort of considerations. So we do recognise that that is a part of the puzzle, but we're also encouraged by other alternatives that are out there and which businesses can use as, as a consensus mechanism if they wish to.
Thank you.
Bring in Gordon MacDonald. Gordon.
Thanks very much, Convener, and good morning, panel. I wanted to ask you about a panel of experts. We've heard conflicting evidence over the last few weeks about whether or not Scotland should have a separate panel of experts to provide guidance. One suggestion was that the guidance that the English panel, which has been established since 2020, is publicly available and it's neutral to any legal system. However, others have highlighted that Scots property law is very distinct to English property law, that the focus south of the border is very much on financial services, and there are concerns on how people are appointed and around transparency and output. So what's the government's view about the establishment of a panel of experts? Should it be representation on the English panel, or should it be a distinct Scottish panel that's created?
I did read some of the evidence you got on this, so thanks for raising that just now. I think absolutely it's something we could consider further. As you say, there's a distinctive Scottish legal system, and maybe distinctive Scottish considerations overall. So our position is we're open-minded to that. So clearly, if the committee's got any view, we'll take that on board as well. So, yeah, we've read that with interest and got an open mind.
But, if we make a recommendation that it should be totally separate, or that it should be representation in an English panel, how would that come about? I mean, would it be an amendment to this bill, or would it require further legislation?
Well, off the top of my head, I don't think it's necessarily got to be in the bill. But clearly, members often table amendments along those lines. So I'm not saying this, it's incompatible with the bill. So let me reflect on that, and obviously the committee might want to reflect upon it as well in terms of how important I think that is. Okay. I would say we do have a lot of expertise in Scotland, so it's not as if we're short of people to give us advice and to, put on to a committee of an advisory committee or panel was set up.
My final point, which is slightly different. Earlier on, you said that Scotland and the UK wasn't behind the curve on this whole issue, but this morning I just read that, and I better read this out properly, that Hashkey in Hong Kong is the first crypto company to list in Hong Kong at $206 million today. So, is the UK not behind the curve because of these transactions already taking place?
I think the question I got was in relation to this legislation being tabled as opposed to what's happening in the wider cryptocurrency economy. So all I can really say is in terms of this legislation, I feel as if we're doing it in good time and do this. I think the UK's bill just passed in the last few weeks or month or two. Yeah. So, I'm quite content with where we are as a country.
Okay, thank you.
Thank you very much, and good morning. I've got some questions around about acquisition and transfer, but before we move on to them, I think in some regards, folk watching these evidence sessions will be baffled by some of it. That's the reality. But it comes back to the simple fact that this bill itself is designed only to ensure that digital assets are included in Scots property law. It's that simple, is it not, Minister?
Yeah, that's the key point, is that anyone listening will know that in Scotland we're modernising our property law to ensure that when it comes to digital assets that people pay for, that's recognised as property in Scotland, just as non-digital assets are. So, yeah, that's the key point to take away from this.
Obviously, a discussion around about this, what should be a simple bill, recognising that those tangents that we've gone off in are things that are inevitably going to crop up in day-to-day life as we move forward. Gordon MacDonald there mentioned expert panel, and expert panels have been mentioned by a lot of witnesses and how they can be utilised as we move forward. But is it beyond just us establishing at some point expert panels to look at how digital assets may impede in other policy areas or other legislation as we move forward? Is it not? It's not just an expert panel that's required. It's a holistic government approach that is probably going to be required here in terms of recognising the impact of digital assets in other areas. So let's take the carbon credits aspect of this that was mentioned last week by Professor Robbie, who was a bit exercised that the carbon credits aspect had been deemed to be out of scope when it came to the land reform bill. We're going to have to pay more attention to this as we move forward in government terms, are we not?
Yes, I think that's right. Some of the issues around carbon credits are pertinent irrespective of whether they're tokenised and turned into digital assets or not. You know, that these debates is just about whether they should be property, perhaps, as opposed to whether it's a digital asset or not. So, you know, but yeah, the general point's correct in that there's, as this develops and becomes bigger and bigger, and if 12% of the population at the moment hold digital assets, who knows where we'll be in a few years and what the implications of that will be. So we have to, you know, pay attention to this, as you say, and look at that.
Okay, I think, again, you know, a lot of questions have arisen from these sessions, but they're not necessarily matters for this bill, which is that simplistic bill. Now I'm going to do the confusing bits around about some transfers and corporeal movables. The bill itself would treat digital assets as corporeal movables for the purpose of acquisition and transfer. And that will create a body of case law to support decisions in this area. Some respondents to our call for views have highlighted risks, including in relation to involuntary transfer and ongoing legal arguments about whether new cryptocurrency is created with each transfer. So what work has the Scottish Government, your team, done to scope out the impact of treating digital assets as corporeal movables in this way? And that's probably...
Well, I think that analogy is really just about the whole concept of property and trying to take the key principles we have in society for property and then translate that into the digital world so that these assets are recognised as property in the traditional way. So that's why the key principles that the expert reference group laid down that are reflected in the bill are there, is because that's the key principles you should follow when trying to classify something as property. I'm not too sure about your point, Kevin, of leading to more cryptocurrencies. I think you said, I was just trying to get my head around that.
So there is those ongoing legal arguments which we've heard about whether new cryptocurrency is created with each transfer. Again, it's that complexity that has been brought in by some of the technologists in all of this. But, you know, again, Minister, and obviously your team may want to come in, you know, my very complicated question, again, probably can be simplified by the fact that we are bringing all of this into property law.
Well, yes, because the purpose, again, of all of the key principles we're speaking about is to stop double selling. So if you were to say that every transaction was lead to more cryptocurrency, that would suggest there's double selling, and therefore, you know, the legislation designed to avoid that happening.
I don't know if any of your team wants to come in.
Wants to add in. I think we both policy and legal want to add something in here. Who wants to go first? Do you want to go first, policy?
In terms of the policy position, it was really one of the recommendations to the expert reference group was that any transfer in relation to ownership should take place with an intention to transfer and the transfer of the control of the digital asset itself. And that, again, is very well supported in terms of the consultation exercise. So in terms of Section 4, obviously that seeks to give effect to that supported proposal. And in terms of the detail of how that works in relation to analogy to corporeal movable properties, I'll probably pass to one of my legal colleagues to fill in the gaps there.
Yes, I mean, I think in essence the point is well made that this bill is simply trying to cause these new digital things to be treated, despite their lack of a corpus, as though they were corporeal, and all of Scots law clicks in around it. And a wee bit that perhaps goes back to the discussion with Mr Kerr about, you know, the audience for this bill and the fact that it is quite a dry technical bill that just plugs into the legal system rather than being a manual for people, because we're not trying to restate all of the common law and how it works for corporeals. We're basically just making the only necessary substitution, which is effectively, whereas you would physically possess a thing, with these intangible things, having exclusive control of it is equivalent to that. And then you let the rest of the Scots legal system run. And one of the very striking things when you kind of dig into the literature and the textbooks on Scots corporeal movables is actually how resonant it is with this language, the concept of control as being the dominant feature of possession comes up repeatedly. So, I mean, certainly in the course of developing the bill, we have done quite a lot of thinking around how this would all flow into Scots law. And one of the reasons it's such a succinct bill and just does plug things into the Scots law framework is that actually it all aligns quite well. And that then gives the courts the latitude and the scope to develop it. As regards the extinction persistent thing analysis debate about whether or not the transfer of a Bitcoin gives rise to a new Bitcoin or whether it's the same Bitcoin being passed backwards and forwards. I mean, as I've said before in this, there's a wee bit here of sort of old wine in new bottles. I mean, that kind of goes on a wee bit with getting change. You know, if you give somebody a £5 note and you get £3 back, is that, you know, notionally 3 of the same pounds you gave them, or are those £3 coins completely different coins from the £5? This is all addressed slightly in, I suppose I was referring to paragraphs 21 and 45 of the explanatory notes, where we kind of touch on this and why the way this bill is drafted basically tries to make that question and that debate irrelevant to the operation of this law. Contra to, if we want to look at other comparators, the UNIDWA drafting, which actually has quite a complex set of rules about treating the emergent Bitcoin that is the product of a transfer as the same thing in some sort of, you know, karmic rebirth of the same asset. We've not gone down that road. As I say, the explanatory notes touch on why.
Convener, I don't think it will surprise anyone to say that in response to Mr Gough, I've not read any of the textbooks in Scots corporeal movables. Just like the vast bulk of the public out there will not have either. And, you know, I'll be honest with you, during the course of this morning, I've had discussion on WhatsApp from some anoraks around about the use of rivalrousness and some of the other buzzwords that we have been, I don't even think we could call them buzzwords, can we? Some of the technical terms that we have used here, including rivalrousness and immutables. None of this really matters in some regards to the folk out there because, I come back to the point, the simple exercise that we are carrying out is to put digital assets into property law and to put protections in for people through our court system. It is that simple, is it not?
As I said before, yes.
Thank you. Thank you, Convener.
And I'm tempted to ask Mr Goff more questions about the karmic nature of this law, but I'll resist that temptation.
Afterwards.
Certainly, I think, the sort of any Buddhist principles have been underexplored by the committee. I might just ask a couple of additional questions. And one, just drawing down a little bit on Kevin Stewart's line of questioning there. I mean, this is a bill that simply establishes that digital assets are property within Scots law. And I wonder if perhaps one of the dangers is we think about kind of the big concepts and think about this actually about big corporate transactions or the future of technology, but actually I wonder if there's some considerations just simply on that. You know, this may well end up being important for things such as civil disputes, for probate, for divorce settlements. And I wonder if there are some considerations because of the nature of digital assets which are different. You know, so, for example, it's much more possible with a digital asset to say you have lost access to that ability. You've lost the access key or what have you. I could imagine in a divorce case going through the courts, you can imagine scenarios where people might try to claim, I don't have the assets you claim because I lost the ability to access my digital assets and all my wealth. Is it? So I'm not asking that specific question, but is there the need to examine any particular safeguards, procedures, technicalities in terms of the application of civil disputes, probate, divorce settlements, or other kind of things that we think of as the nuts and bolts of kind of Scots law and civil law, if the subject of those proceedings will be digital assets?
Again, this bill is just trying to achieve a simple thing, as you outlined in your opening remarks, and other legislation addresses many of the other issues that you've mentioned there in relation to perhaps divorce cases or whatever. And, you know, I'm sure members are familiar from their casework that in divorce cases, often things are, you know, potentially hidden, which are not digital assets. So that applies anyway, is my point. And that's just part and parcel of the world in which we live, irrespective of whether it's digital assets or not digital assets. So, you know, I'm content that we can just focus on this bill achieving what it's set out to achieving. And there's lots of other issues that have been discussed, understandably, because it's part of a wider debate that have come through evidence to committee and that members are interested in. But I just make the point on behalf of the government that this is, I believe, achieving what it's set out to achieve.
And I think the approach we're taking is we want to just try and be as diligent as possible and trying to pull that apart, which is why I think we've been asking many of the questions. Similarly, just following on from Gordon MacDonald's line of questioning there, we've talked a bit about what might happen in other jurisdictions, but actually particularly what might happen across the rest of the UK. There's been discussion about an expert group being formed. I just wondered what sort of dialogue has been established between the Scottish Government, the UK Government, indeed the other jurisdictions within the UK about actually making sure that we keep pace and input, because there is clearly going to be an overlapping nature to this as we go forward.
Yes, I mean, officials and colleagues are well aware of what's happening elsewhere in the UK, so I think that's an important point, and we'll make sure that that's the case going forwards.
Great. And look, just finally, I wanted to just ask one final question, is that we've heard that law reform is urgently needed in other areas of Scots law, for example, private international law, debt enforcement to accommodate digital assets. And I think it stands to reason these are things which it may be that it's two people resident in Scotland who are exchanging or in dispute, but it is just as likely that they're going to be in different jurisdictions. And I recognise that international private law, in and of itself, is something that may be at the frontiers of what we need to establish. But I was just wondering if the Minister could outline what the government's thinking about how this work might be taken forward and what consideration has been given to it.
Yeah. Clearly, I can bring the committee's views to the attention of the Justice Secretary, who will no doubt be looking at these issues, and also these are also issues for the Law Commission to get their advice, because a lot of the steps we take are in response to recommendations from the Law Commission. So, if you want, I can happily write back to committee on that.
Thank you. And just finally, and I would recognise this is an unusual bill. It is both kind of focused and short, but it is also expansive, I think, in some of the concepts that it deals with. I just want to invite the Minister, are there any sort of issues or items that he wants to note, just as we close, that perhaps we haven't touched on in the questions that we've asked this morning?
Not really. I would just commend the committee on, I think you've had 3 evidence sessions or so on this bill, which is quite comprehensive, and having read the evidence you received, it's been very, very illuminating and interesting. So thank you for the hard work you've done as a committee on this.
Well, that just remains for me just to conclude this public element of our meeting this morning. Can I thank the Minister? Can I also thank the Bill team? And I do note that the Bill team has been very diligent in terms of paying attention to our evidence sessions, and it's something that the committee as a whole has noted and really welcomed. So I just really want to put that on the public record as well. So thank you very much for this morning, but also the ongoing work. And with that, I will draw the public session to a close, and we will suspend for 5 minutes. Thank you very much.